Welcome to the JSE Market Data Policy Guide. Our policies are designed to help market data professionals and data distributors understand the use of each policy, emphasize the applicability thereof, and enhance compliance with the regulations pertaining to the use and distribution of our market data. There are 5 documents which make up your agreement with the JSE, and they are the JSE Data Agreement or Indices Data Agreement, the Product and Services Form, the Market Data Policies or Indices Market Data Policies, the JDA, which is the JSE Data Agreement, or IIDA, which is the Indices Data Agreement, as well as related price lists. Finally, there might be technical documents if applicable. In this session, I will be taking you through Dispute Resolution Policy. It pertains to the applicability, disputes applicable to this policy, and the arbitration process. Applicability. Any dispute arising from the JSE Data Agreement is governed by this policy. This policy is a separate, divisible agreement from the rest of the data agreement, effective even if the data agreement is terminated. Disputes applicable to this policy. Disputes covered by this policy include, but are not limited to, the existence of the data agreement, the interpretation and effect of the data agreement, the parties' rights or obligations under the data agreement, rectification of the data agreement, breach or termination of the data agreement, or any matter arising out of the breach or termination. Arbitration process. Subject to the Consumer Protection Act, and to the extent applicable, the arbitration process is as follows. The parties must agree on the arbitrator, who must be an attorney or advocate on the panel of arbitrators of the Arbitration Foundation of South Africa. The arbitration must be held in Sandton, South Africa. Parties must make an effort to complete arbitration as soon as possible. The arbitration will be governed by the Arbitration Act 1965 and must take place in accordance with the commercial arbitration rules of AFSA or its successor. In spite of the provisions of this policy, the High Court of South Africa will have jurisdiction to determine any proceedings instituted by way of notice of motion by any party in which interim relief or urgent final relief is claimed in relation to the data agreement. Costs of the arbitration will follow the outcome of the process. Thank you. For more information, please email mdclients@jsc.co.za.